Alright, welcome to another exciting session on the Isaac Humanitarian Foundation Power Pack classes. My name is Femi, and of course I'll be taking you the use of English. Alright, today I'll be touching something quite exciting, and of course it has to do with the lexics and structure aspect of your examination. Of course, the topic is registers, but I'll be touching the WAEC rudiments. Okay, first let's touch the facts and issue. When we talk about facts and issue, we're talking about the essential words. Okay, you cannot understand a topic as this if you don't get the meanings of each of the individual words. So when we say registers, there's a definition for it. When we say WAEC rudiments, of course, we have a definition for it. Alright, so the purpose of the examination itself, having this topic, is such that the examiner wants to test your knowledge on the different professions listed in your syllabus. And of course, whether you have the gamut of what exactly the terms used in those professions are. For instance, if we're talking about law, which is a profession, there are certain words or terms that are used in this profession. So if you're looking through your syllabus, your WAEC syllabus, you are going to discover that there are certain professions that have been listed for us, and we're expected to understand different words under those professions. By doing that, we are talking about what? Registers. Let me give an example. While you were in your secondary school, if you have a JSS1 class, and we have an SS3 class, this class has what we call a register, which is a class register. Is that not so? Now, the things you will find inside this register will be the names of students in this class only. By the time you get to SS3, you don't expect to find the names of students in JSS1 in SS3 register. Therefore, you don't expect to find words under law in medicine. They are specific to each profession. So, we call it what? Registers. So there are words that are registered under each profession. Having said that, I'll now proceed to giving a short definition, then giving a particular, okay, probably we'll have to pick the first one I have here, maybe we'll pick law, and then I'll identify some words and give a passage, and I hope that that should suffice for the class. Alright, so permit me to do just one or two highlighting on the board. Okay, if you're just joining us, a few things have been said. Alright, so registers, here's the definition. Registers refer to the academic endeavor. The academic endeavor of use of English that studies words as they have been registered under different professions. Okay, an example, law, you could have lawyer, a lawyer, yes. You can have a bailiff, okay? You can have a subpoena, etc. Okay? Same as you can have under the field of engineering. You can have measurement. You can have construction. You can have a safety belt, etc. So for the purpose of this class, I will tabularize a few words focusing under the field of law. Alright, so profession, law. Okay, usually in your syllabus you see law and order. Okay, so I'll list out the words, then we'll begin to take them one after the other. Okay? quickly look at these. I have a few words, about 15 of them. These are very basic, okay? In some advanced classes like your UTME or your A-level exams, there are some much more advanced words than these. Okay, if you go through your past questions, you most likely see these words that are put on the board. Okay, you see mens rea, you see actus reus, you see magistrate, you can see appeal, defendant, plaintiff, vicarious liability, provocation, judgment, crime, treason, writ of mandamus, courtroom, adjournment, and guilty. Okay, all of these, having explained them, I'll try my best possible to give a kind of passage where I will demand or expect us to actually put in the correct expressions. Alright, so the first one is mens rea. Mens rea. Okay? The mens rea means intention. Intention. In the field of law, intention has to do with what someone plans to do. Okay? So this is a principle of law, that it must come in agreement with what we call the actus reus. So you see mens rea on top, actus reus below. So the actus reus is your action. For someone to be declared guilty, then we have to say that your action and your intention have met, or they agree. Let me give an example. If you have a friend and the friend has actually annoyed you, or you probably told the friend that you do something to hurt them back in return, which is not good, you would see that you just said that. Probably you didn't know the person had injuries on the leg and you mistakenly stepped on the person. In such a case, if it will be judged, you will discover that though the person said he was going to hurt the other person, but his action, he didn't plan that that was what he was going to do. That was a mistake. The action must meet with the intention before you can say someone is guilty. A child running with a pot of water, hot water, didn't know, he slipped and poured the water on somebody. Probably he had already made a statement initially to hurt that person. You see that in that case, the case, we don't have the intention and the actions to rhyme in. It was not intentional. Okay, but when it is intentional, then guilty mind will be what? It will be described. Okay, so mens rea, don't forget, is the intention. Why actus reus? We are talking about the action itself. You can say actors. That should be the guideline for that. Alright, the next one is magistrate. Okay? A magistrate, this is a legal officer. Legal officer of the lower courts. Of the lower courts. Okay? In the magistrate court that is headed by the magistrate. A lot of funny scenarios you see there. The magistrate himself is the lawyer, at the same time is the judge. He questions, cross-examines, okay, and interrogates, the defendant in the court of law. Okay? The next thing is the appeal. Appeal. This is a plea. The meaning of plea is, in layman's term, is to beg, to plead. Okay? Or a begging. A plea against a particular judgment, okay, from a court. If you go to the court of law and you are charged for a case, and the judge already declared that you are guilty, if you are not satisfied with that, you can appeal. That is, you can plead against it in another court, okay? But the court must have what we call jurisdiction to try or hear you. Okay? So appeal basically has to do with what? Pleading. That the judgment that was rendered should be reconsidered, because you're not what? Comfortable with it. The next one is what? Defendant. Okay? The defendant. That's the accused. Another word for that is accused. Okay? The person who in the court of law is standing and is trying to claim himself or herself. That is the word? The defendant or the accused. Okay? The plaintiff. Plaintiff is that person who brings a case. Plaintiff is the person who brings up a case against another person in the court of law. Okay? Probably you have a grudge, or someone has offended you and you need to get remedy for that particular court. You go to the court of law and you lay a complaint, or you bring a case against the person who has hurt you, then you are the what? The plaintiff. Now, vicarious liability. Okay? We all know that liability has to do with something negative. It's not positive in nature. So when we say vicarious liability, it means that you are suffering from your own action. Okay? Nobody will bear the burden for you. You you suffer your own action. Let me give an instance. Okay? If I'm to stand for somebody as a guarantor, the meaning of a guarantor is that person who stands to say that what this person is about to do, I support it. If the person does not achieve it, you can come to me. I will actually do what is expected to do. So, if someone has stood for another person as a guarantor, and then the person you stand for, you didn't know that the person is a person of questionable character, the person's character is bad, and you went there, you supported him, maybe it's your friend, you say, this friend of mine, let me stand behind him solidly. I'm sure that what he wants to do, there will be no issues. Eventually an issue arises. You'll be vicariously liable. That is, they will come and pick you up when they can't find the person. So vicarious liability simply means what? You are being responsible, or you are suffering as a result of what? Your own action. Okay, the next thing is provocation. Okay, provocation. This is an act of getting someone to do something or not to do something. Okay, provocation. The act of getting someone to do or not to do something. If I'm provoked, I could hit somebody. If I'm provoked, when I need to help someone, I might not help the person. Okay, so provocation is an act that pushes someone to do something or not to do something. Okay, judgment. Okay, this is the sum. This is the sum arrived at. This is the sum arrived at after taking evidence. After taking evidence. So, what is an evidence? Evidence is that thing that is material. It's something that we can see, that can be used to prove that someone is guilty or someone is what? Innocent. So, evidence. After taking evidence, a judgment can either be positive or negative. The judgment could be that someone is guilty. Judgment could be that someone is what? Innocent. Do you understand? So basically, judgment is the sum arrived at, or the total accumulation of all of what I can say, not going to form an opinion. Okay? After taking evidence. That's what judgment. Then we come to number 10, crime. Okay, crime. That which is against the law. Crime. If you have a set of law, okay, and someone decides to go against that law, he has committed a crime. Usually, in this context, in some layman dictionary, you will see that crime could be in social context. But in the real sense, crime is not a social issue. It has to do with the criminal exercising or showing wickedness to a great degree. Not really social relations as in friends offending each other, no. If you have someone coming around stealing public funds, or someone moving around, entering into people's houses with a weapon, trying to scare them or to get them, and it's against the law, okay, that is what? A crime. Now, treason. Treason is a crime against the state. Treason is a crime against the state. Let me give an instance. If Lagos were to be a country, and Lagos was in a war, probably Lagos wants to fight Ogun. Let's assume Ogun State is another country, and the two of them are going into battle. If we have somebody who is a Lagosian, who is supposed to support the Lagos army, but he went behind and went to give the information of the Lagos military, the military of Lagos, to give it to that of Ogun State. Are you listening to what I'm saying? If he's found, or if the secret becomes leaked, and is discovered to have done that, then the state will declare a case against him and call it what? Treason. Okay? So that's a crime against the world. The state. It's a treasonable felony. Okay, there are other forms in which a treason can come. Okay, especially when you do not obey the law and it affects your state. It's what? A treason. Okay, writ of mandamus. Okay, the writ of mandamus is a written document from the court asking someone to do something or not to do something. Okay, usually you see people who go to the court of law to beg that the court of law should help them tell someone to stop doing something or not to do that thing. Okay, the person could be an official of the state, the person could be a normal citizen, okay, but regardless of that, the person is being mandated, okay, to do something or not to do that thing. Okay, number 13, courtroom. This is as simple as it looks. It is interpreted as sin, a room where judgment or cases are judged, okay, or a room where cases are heard, okay, that is what a courtroom. Adjournment. This is a term we use to say that something that is currently ongoing has been moved to another date. Okay, so in the court of law, it is not unlikely for us to see this. There are times where the judge is trying to work on a case and the case is not forthcoming. Let me give an instance. There was a case brought against a husband and a wife, okay, in the court of law. It was difficult to establish, who was guilty, where 3 friends on April 1st, which is April Fool, decided to visit their friends, that is the husband and the wife. So they dressed in black on black. You know the way you prank yourselves. That's why if you want to prank, you know who you are pranking before they eventually end up pranking you. Now these ones got into the house, knocked on the door. Before the owners of the house could open the door, they gave the door a very heavy kick. They were all dressed in black, 3 of them, looking like robbers, and they carried toy guns. You can imagine that. So busting in there, they didn't know that prior to their coming, 2 weeks before their coming, the husband and wife had been learning karate. Okay, they came to prank. One thing led to the other. The husband and wife maneuvered the 3 of them. It was at the point of trying to strike a blow on one of them that the person screamed, "It is I, your friend, Shegun." And then he removed the mask, only for them to see that truly it was their friend. Why did you guys do this? Others get up. By the time they tried to raise the others up, they discovered that one of them is dead. Now, it became an issue. Okay, so the husband and wife had to go to court. No, sorry, before they got to the court, the 3 of them, together with the husband and wife, saw that it was a mistake. The husband and wife acted in self-defense, right? But these other people didn't want the story to go out, so they all planned to bury the case. At night, they took the body, wrapped it in a cloth, put it in the trunk of a car, and drove to a hillside and decided to throw the body off. It was in the process of throwing the body off that someone, a patrol or a security guard, was passing around, and that man flashed torchlight. So they took off, abandoning the car. So it was the car that was used to trace them and became a court case. Now, in the court of law, it was discovered that truly the guy who died did not die from a blow in the room. In fact, the guy died about 7 hours after he had been struck to the ground in the room. So obviously something was wrong. The case had to be moved to another day so that they can carry out other investigations. And of course, they contacted the doctor. The doctor carried out what is called an autopsy. Autopsy is the examination you carry out on a dead person to determine the cause of the death. And in the end of it, what was discovered was that the guy actually died after they were throwing the body. So he smashed his head against the rock. He was only unconscious in the room. So he smashed his head against the rock, and then they asked who threw the body. It was the 2 friends who carried the guy, and so they were the ones who were convicted. Okay? So in the case though, it was manslaughter and not murder because it was not intentional. They didn't know. So what I'm saying in a sense is that adjournment means a case that is currently ongoing, okay, can be moved to another date. Do you understand? Therefore, the term we use for that is what? Adjournment. Guilty. Guilty means to be found wanting. It means that all the allegations against you are proven to be true. Within reasonable doubt, like when you check it, there is no doubt at all that this person is not, guilty as charged. Therefore, when we say guilty, we are saying that all the accusations against somebody have been found to be what? True. Now, having explained this, please take note of this. In your exams, you might not know which of the fields of study or professions will be mentioned. We don't know which one that will be touched. In fact, the class alone that you'll be having might not even be sufficient. So you need to do extra practicing. In the previous class, I think I gave you panaceas, okay, to linguistic maladies. When I mean panaceas, I mean solution to linguistic problems. One of the points I raised there is that you should acclimatize yourself, okay, with seasoned authors and writers. I gave another point there that you should what? Fraternize with the dictionary, so that you can pick up some words in other, different professions and update yourself on them. So please, I want you to, after this class, still go ahead, probably use a thesaurus or probably use a dictionary, look for terms under law, or you can use the internet, Google out some words, and try to see how you can actually memorize them for the purpose of your classroom experience. Alright, so with this being said, I'll now proceed to putting up a very short passage on the board, which will determine whether we have understood this or not. And that will be in the very next class. I'll see you then after this time out. Once again, please don't forget, initially I said that this project is brought to you by ICT Humanitarian Foundation. And of course, this is the hub where you can find resourceful material that will help you in the course of your academic endeavors. Alright, with that being said, still on registers, have a short passage on the board, and a few of those points I raised earlier on, I'll try to see how much of it we have simmered down, and of course, let's pick through the correct answers. Alright, so if you're ready, I'm set. The passage on the board, I'm sure, is something you've not seen before, so try to make a sense of it. When the news broke, everyone in the family became terrified. No one prays to have a dash in the court of law. The plaintiff had brought a dash of armed robbery against the pastor, whom she claimed she recognized. Immediately the police was involved, and a dash of arrest was issued in the court. While the dash stood in the dash, his dash fought tooth and nail to dash in. Series of examinations and dash were done, and what moved the judge the most was the tears in the eyes of the dash. But for want of evidence, the case was dashed to a later date. Let me take that again for those of you writing or probably playing this video over. When the news broke, everyone in the family became terrified. No one prays to have a dash in the court of law. The plaintiff had brought a dash of armed robbery against the pastor, whom she claimed she recognized. Immediately, the police was involved, and a dash of arrest was issued in the court. While the dash stood in the dash, his dash fought tooth and nail to dash in. Series of examinations and dash were done, and what moved the judge the most was the tears in the eyes of the dash. But for want of evidence, the case was dashed to a later date. Interesting story, right? Imagine pastor, you know, there's corona out there, so there's no business again. It's almost like people will even condemn the person before getting to the court of law. But that's not our focus. Now, for number one, we can see here we have options A to D. Option A says case, option B says issue, option C says problem, and option D says accusation. When the news broke, everyone in the family became terrified. No one prays to have a dash. Don't rush to pick your answers. Whenever you get to the examination hall, read through the passage. Go ahead, read all of the options. Are we together? Then come back and start to read the passage again, line by line, up to the point where the space or the gap is. Then you trace the options as labeled under the number. Do you get that? So having read it, that's why you see I read twice. Having read that, we are now tracing it to answer the individual questions. When the news broke, everyone in the family became terrified. No one prays to have a dash in the court of law. Is it a case? Is it an issue? Is it a problem? Is it an accusation? Under elimination method of picking answers, it is logical. But there are some people, I don't know how they pick their answers. Even if you have never come across a topic like this before, or registers like this before, looking at the options you have, with the determiner A, this is a definite determiner, and of course the verb, okay? Whatever option you are picking, it makes no sense when you are saying a issue, or you are saying a accusation. No. When you have a vowel starting another word, of course you know that will be what? An. Okay? So, By elimination, we are removing issue and accusation. So what we have is problem and case. Nobody prays to have problem. That's wrong. Okay? Because if you pick this, you know this one, I'm a new problem. That's what we play in your head. Okay, but case is the correct answer. You know, tell me all right. I will go exam for your case. So this case here talks about what can be heard in the court of what? Law. Now look at this. The plaintiff had brought a dash of armed robbery against the pastor. Now this is collocation. Is it a charge of armed robbery? Is it a plea of armed robbery? Is it an appeal of armed robbery? Is it a fight of armed robbery? In the court of law, sometimes here might not apply, like a fight on the street or wherever you are, fight could apply. But in the term of law, it is what? A charge of armed robbery. That's why you see in probably your objectives, you hear the man was charged, dash armed robbery. Is it for armed robbery? Is it with armed robbery? Is it of armed robbery? Is it for armed robbery? It is what? Charged with armed robbery. So charge is the correct answer. Number 3, okay? Immediately the police was involved and a dash of arrest was issued. Look at this. A, is it a document of arrest? Is it a warrant of arrest? Is it a charge of arrest? Is it a verdict of arrest? It cannot be verdict. Because verdict and judgment are same. Verdict is the proclamation or the statement that the judge gives having collected evidence, okay, and he has proved whether someone is guilty or not guilty. So the statement to say that whether someone is guilty or not is called the what? The verdict. Okay, it could be the same as what? The judgment. Okay, so invariably it cannot be. Of course, it cannot be a verdict of arrest. No, it cannot be a charge of arrest. No. It's not a document of arrest, it is what? A warrant of arrest. Okay? Next, where is that? Number 4. Was issued. Now in the court, while the dash stood in the dash. Now this part has to do with inference. Okay? There are some answers that are implied, some answers are inferred. When we say inference, when you infer, it means having looked at everything you've seen, from all of the things you've been seeing, you can try to make an opinion. It's not really that you know it, you're trying to make an opinion out of it. Okay? So, in essence, this is an inferred question where you have to pick an answer based on the things you've seen. So definitely, you can see that what? It is who stands in the witness box is that person that is being accused. Later on, you can call them witnesses, okay? But in a crime, in a criminal case, the burden of proof lies on the person who affirmed. So basically what we are saying here is that while the dash stood in the dash, his dash fought tooth and nail to dash in. So here we can see that the person we are talking about is not the person who is complaining. It is the person that is being accused. Therefore, it is what? The defendant stood in the witness box. Okay? While the witness box is another option. Option here we have stood in the bars. Option B we have stood in the handcuffs. Option C we have stood in the room. Option D we have stood in the witness box. It can be room, it can be handcuffs, it can be bars. The answer is what? Witness box. If you have ever been to the court of law, you see a box where the person who is accused or where witnesses stand to answer questions or to give opinion or things they've seen or heard. Okay? So, the answer here is what? Witness box. Okay? Is dash fought tooth and nail to dash in? A, is it his counsel? B, is it his friend? C, is it his father? D, is it his church members? Don't forget it's a pastor. You can put that question there to just distract you. It is neither of church members, father, nor friends. The answer is what? Counsel. Who is a counsel? Counsel is like someone who advises, who gives legal advice. Okay, take note that once something happens to you, it's just so ironical that in a country like this where there's total disorder, when a case happens around you and you need to take up an action, the police or the soldier is not, it's like you are procuring the use of military people to perpetrate an unlawful cause. Okay? The military are not saddled with the responsibility of catching somebody, trying the person, dealing with the person, or sentencing the person. No. If at all the military will be involved, it should be for arrest or to restrict the person from evading justice. But in Nigeria, once there's a fight between two people or someone stole your phone, go and call soldier or you call SARS. That's the next thing. It is very unlawful. Okay? It's a crime punishable in the law, but I doubt whether it's applicable in Nigeria. Okay? So, the person who actually advises whoever a case has been brought against is his defense counsel. He performs the duty of advising the person, telling the person what the case will look like, what the person should say when he gets to the court of law, and what he or she should not say. And of course, it is called what? A defense counsel. So counsel is the correct answer there. Number 7, indict. What option did I go for? Okay, so is it indict him? A. Is it to vindicate him? C. Is it to pressure him? D. Is it to ill him? It can't be any of them. It cannot be pressure. You cannot pressure someone who needs to be saved. He has been accused. So what he needs at that point in time is to be taken out of that case, to be exonerated. Therefore, the word we use for it is not indict, it's not pressure, it's not ill, it is what? Vindicate. To vindicate someone is to prove that the person is not guilty. Okay? To argue for the person. Are you getting that? So the word for the answer is vindicate. Alright? Now the next. Now series of examinations and dash were done. Now that option there is examination and dash. A, is it cross-examination? B, is it polar questions? C, is it decisions? D, is it documentation? Okay? In the court of law, when you have examination, what follows immediately is cross-examination. Now, what is examination? If I come to the court of law and someone says, probably I stole the marker, the examination is that point where my own lawyer will ask me questions if I've seen the marker before, if I know if the person who is accusing me owns a marker, a lot of questions. Once he does his own and he asks me the question, the lawyer from the other side, okay, will come and cross-examine me. By cross-examining, I mean when my lawyer is asking me questions, he will be noting everything. Okay, he replied like this, he said this, he said this. Then he will now come back. The lawyer for the other person will now come and say, sir, while you were being examined, you said this, you said that, you said this. I just want to cross-check. Are you saying that this is this? Are you saying that that is that? So we have examination and cross-examination. It is not polar questions. Of course, polar questions are yeses or no questions. The question where you are required to just say yes or no, you are not required to explain. Of course, some people evade that in the court of law by saying that I would say yes with explanation. Okay, then number option C, decisions. Of course, this is irrelevant to the case. Okay, documentation. This is clues, but not the answer. Therefore, it is what? Cross-examination. Then the last but not the least, okay, we have, I think we have 2 more options there. Yes. We're done, and what moved the judge the most was the tears in the eyes of the answer here is plaintiff. The person who is claiming that he has suffered a loss. Okay? The person is crying, please deal with this person, please. Probably the judge himself or herself has been in the situation of being robbed before, and she knows the trauma. Or she knows what it means to be betrayed by someone you respect a lot. Imagine accusing a pastor, the pastor of your church, that he broke into your house with a gun and you recognize him. You know, it can be traumatizing. Okay, so the tears in the eyes of the plaintiff move the judge. Okay, but look at it. But for want of evidence, we didn't have items to show that maybe if you had seen a picture, even picture might not be admissible. Okay, or probably there was a witness, there was someone who was there and to say that okay, he saw him, he heard him, or they went to the house of the person and they asked where the man was the night before. And the family members could not have a reasonable thing to show. Essentially, it will be what? Dictated or stated that what? Such case has no face. It will be adjourned or postponed, which is the last option. Okay? But for want of evidence, the case was dashed to a later date. If in the passage we didn't have to a later date, so the case was dashed, it's either your option would be the case was thrown out or it was quashed. That is, destroyed or set to no longer have the ability to hold. Okay? But here we have to another date. Therefore, the answer will be what? Postponement or adjournment. Okay? And that I explained in the previous class. Alright, so this being said, I think we'll be able to see that if you read the passage through, it makes sense now. When the news broke, everyone in the family became terrified. No one prays to have a case in the court of law. The plaintiff had brought a charge of armed robbery against the pastor whom she claimed she recognized. Immediately the police was involved and warrants of arrest was issued in the court while the defendant stood in the witness box. His counsel fought tooth and nail to vindicate him. Series of examinations and cross-examinations were done, and what moved the judge the most was the tears in the eyes of the plaintiff. But for want of evidence, the case was adjourned to another date. Okay, and that ends that on register. So take note, basically, that is registers about law, the discipline or the profession of law. So take note as a recap that registers basically refer to the list of words, okay, that have been registered under a particular field or discipline, okay, such that it enables the speaker to talk about that discipline with precision, okay. And of course, your WAEC rudiment. The expectation of WAEC is that you are able to pick, you have a syllabus where these professions are listed. If you have never come across them before, go back to your syllabus and look through. Okay, you see transportation, you see insurance, you see media and publicity, journalism, the likes of them. Okay, so we'll move to another one in the next class. I'll see you by then.